Hello friends, in the series on the income tax cases, today we will discuss a very important case. The name of the case is Deputy Commissioner of Income Tax versus Mastech Technologies Private Limited. This case has been reported in 449 ITR at page number 239. The matter has been decided by Supreme Court and the date of the judgment is 3rd November 2022. This case is regarding section 148 notice and the assessment year involved is 2008-2009. In this case, the Supreme Court reversed the judgment of the Honorable Delhi High Court, which quashed the notice under section 148 and the assessment done in consequence to that notice. The facts of the case are very interesting. In this case, the assessing officer issued notice under section 148 to the assessee. The assessee asked the reasons and then the reasons were supplied to the assessee. After that, that assessing officer was transferred and the second assessing officer took the charge of that assessing officer. Simply meaning thereby that suppose there is ward 4-2 and there is an assessing officer Mr. A. Mr. A was transferred and then Mr. B took the charge of that ward 4-2. Then second assessing officer issued notice under section 148 to the assessee. The assessee again asked the reasons. The reasons were supplied. The assessee raised the objections. Objections were disposed of and the assessment was completed. Now the assessee filed the writ petition against this assessment order in the Delhi High Court. The contention of the assessee was that when the second assessing officer issued notice under section 148, then it means that the first notice under section 148 has been withdrawn. This was the contention of the assessee. And the second contention was that when second assessing officer issued the notice under section 148, at that time it was time barred and the fresh reasons were not recorded by the succeeding assessing officer. This was the contention of the assessee. The assessee also said that when the second assessing officer took the charge of the ward, then he didn't mention that it was the continuation of the earlier proceedings. So on these grounds, the Honorable Delhi High Court was convinced and quashed the assessment order. So the department filed the special leave petition against this order in the Supreme Court. The contention of the department was that before Supreme Court, here section 129 applies, which says about the change in incumbent in the office. Simply meaning thereby that the transfers are a casual process in the department and it happens that one assessing officer took the charge of the another assessing officer. So practically it is not possible and logically also that officer took the charge of the earlier assessing officer, and the section 129 says that the proceeding starts from there where the earlier assessing officer has stopped the proceedings or the proceedings were at that stage. When the new assessing officers took the charge, the proceeding starts from there. And the department also said that the fresh notice under section 148 was not warranted or required to be issued by the succeeding officer. So it was the contention that even if the second assessing officer has not issued the notice under section 148, then it will not make any impact on the whole assessment. The department also said that the issue of second notice will not tantamount to dropping the earlier notice under section 148. So in this case, the department was very logical also. And one more point on which the department took the ground was that the assessment order was on the basis of the first notice. and the first notice was issued after recording the reasons, and that was also within time also. So the Supreme Court was impressed by the contentions of the department and reversed the order of the Delhi High Court. So friends, this case is very important. Even I was a little bit confused on this matter before I read this judgment. So I have also got very much clarity on the subject by this very good written judgment of the Honorable Supreme Court. Once again, I am repeating the name of the judgment. The name of the judgment is Deputy Commissioner of Income Tax versus Mastech Technologies Private Limited, and this case has been reported in 449 ITR at page number 239, and the date of the judgment is 3rd November 2022. Thank you, friends.